Michael Bilal.
Very nice to present to the
Unexpected. Well, the seminar that's going on a little bit more roughly than expected, but still, nevertheless. Right. So basically, we have a few IT problems here. One of which is that we cannot hear you. So what I propose is that we have our speakers do their thing, during which time I will scamper up and try to tech who can do whatever techie stuff they do. And hopefully everything will be great by that point. I'm Iain Brassington. I'm a lecturer here at Manchester. Jorge is in charge of the Jewish North and he has organised everything. We have a slight problem in terms of the speaker that we had expected to have, in as much as she is ill and therefore cannot speak. However, we do have our respondents. So we're going to work on the principle that the respondents will be able to say what they wanted to say. And on that basis, you guys will be able to deduce everything important about Veronica's book. It's a little bit ad hoc and a little bit ramshackle, but I prefer to think of it as endearing. So without further ado, I'm going to hand over to Jorge, who has the running order, and I'm going to go and find a tech person from somewhere to solve our problem.
So good question. Is it working because the image is black?
That's just because, oh yes.
Marichuy, ¿la puedes ver?
Sí, puedo ver a la audiencia, pero no a ustedes. Pero no a ustedes que están enfrente, como que la cámara está enfocando hacia la audiencia, como si...
The camera is the other way around. Well, that's fine.
But anyway, I'll go get some tech people that we can.
Thank you very much. Thank you very much for your patience. I guess you can hear my voice. Is that okay, Marichuy? I can see you. Perfect, good. Well, I'm representing here Juris North. First of all, apologies for Veronica. On behalf of Veronica, she had a health issue. She was trying her best to come. She had to cancel the train ticket, and then she was going to do it online. So she asked me to say thank you very much. We thought about postponing. Then I had a chat with the commentators, and we decided to run the event. I shared with you in advance the monograph. So the plan today, I do a bit of an introduction. I'll go back to Marichuy. She will introduce herself and what we've been doing for quite a while. And then I'll introduce each of the commentators in order. Is that okay, Marichuy? Cool.
Yes.
During if we go online, we're actually 10 people at 9 different locations. We have Aberdeen, Peter Cerne, Durham, our professor here, William Lucy, Central Lancashire, we have Ian Turner, Hull, with Fear, Liverpool, we have Mike Gordon, Manchester, myself from Manchester Metro and Manchester Metropolitan, Newcastle, we have Josh, I don't see if he's around, Surrey, Verónica, our Verónica Rodríguez Blanco, and Westminster, Anna Chronopoulos. We've been running this show for about 8 years. 2015 was our first meeting. It's just a coincidence, Iain was our first presenter 8 years ago. He was talking about cannibalism. Very briefly about your North, Veronica, we decided, we had a chat over the phone, and we got to a point. She was a senior lecturer at the University of Birmingham, and I was finishing my PhD, or I had finished my PhD at Manchester Uni, and got my position at Manchester Met. We realized that all the discussions in terms of legal philosophy and political philosophy were happening in Cambridge and Oxford at the time. There were some Brazilian colleagues starting in Edinburgh. I'm talking 8 or 9 years ago. So we decided to do something together. Veronica on her own, or Jorge on his own, we couldn't. So we decided to invite other people. That's how we came up with Juris North. William was one of our first joining and founding members. Then we had Mike Gordon in Liverpool. And Hal at the time, now in Aberdeen, we had Peter Cerne. And that's how we started. 5 people decided to, rather than compete, to collaborate. At that time, we were doing face-to-face discussions once a month in January, exactly what you asked me, January till March, and then September, October till December, original papers. And what we do today, we don't have Veronica, we use Rolfian methodology. In the sense, we have one expert And the rest of us, we don't have professors or students. We are simply people interested in learning from each other. And that has created quite a welcoming environment. Well, it's been 8 years. We've been through the pandemic, online, hybrid. I feel one of our very first people coming here, some familiar faces. I can see some familiar names online as well. But thank you very much, and thank you for your patience. And in particular, now you have asked, so I can tell you face to face. Thank you, Iain, for hosting. I mentioned your name because you were our first speaker at the time. I don't have anything else to say, Marie Chewy, so we can start with the commentators. I'll let you do your part of the introduction, and then I'll introduce William. Is that okay?
If I understood clearly, yes, it's okay. I think that there is a little bit of delay. Can you hear us clear? Yeah. Is it okay? Yeah. Okay. So, well, I'm very grateful to first of all, to you, Jorge, to the Juris Not Networking, and to all of the colleagues who are here with us in Zoom from Colombia, from Brazil, from Argentina, from Italy, from Mexico, from the National Autonomous University of Mexico. Imer is here with us. He has been a great support in this Juris Not discussion group. So we started last year with the discussion about Kelsen, and so I'm very happy that we are starting again with you, Imer. Thank you for being here. Thank you to all of you. Thanks to my former the professors in Manchester. I'm sorry I'm not there, but very grateful to Iain, to Professor William Lucy, and obviously to Jorge. I think that this is a great start of the year for group discussion, and it's very important that it can be a hybrid event, so we can keep on collaborating and discussing, even though we are not in the UK. If we are in Mexico, in Colombia, Argentina, Italy, all over the world. Thank you so much. And thank you to Verónica. I think that she's here, sorry. I'm not sure she's the one, but I have a Verónica here in Zoom. I hope she is, because it's a celebration of her book. And I am also very grateful to her because she was the one starting this collaboration. So I'm very looking forward to listen to the commentaries of the book and have a good discussion this afternoon. Thank you so much, Jorge. I don't know if I am missing something.
No, perfectly well. Here is explaining, because we are co-hosting here in Manchester, we had a bit of a technical issue with the sound. So please be mindful and be patient if we kind of, ask you a few times the same question. So I'm going to start by introducing now our first commentators, and in particular, I will give the floor to Professor William Lucy. We're going to comment throughout all the book. We have the first one, Professor William Lucy from Durham Law School here in the UK. He will be commenting chapter 1 and 2. Then we will have Professor Dr. Imer Flores from Instituto de Investigaciones Jurídicas, Universidad, Nacional, Autónoma de México. Imer, muchas gracias por tu participación. Un placer. Vamos a comentar capítulos 3, 4 y 5. Luego, nuestro amigo de tantos años, otro amigo de la casa, Profesor Dr. Andrés Botero Bernal, Universidad Industrial de Santander, Colombia. Tenemos el capítulo o chapter 6. And our new enterprise with Herlinde, because Herlinde, we had the pleasure, she's part of our council monograph with her publisher, Professor Dr. Herlinde Pauer-Studer, Department of Philosophy, University of Vienna, Chapter 7. Herlinde, a pleasure, and thank you for your phone call. I have to tell the audience, Herlinde was so kind to call me earlier because we were having technical difficulties. So Herlinde, thank you very much for your patience and your understanding. Luego, gracias Andrés, gracias Imer, gracias Herlinde, and thank you William. And last but not least, before I reintroduce Professor William Lucy, I have to say, people, we've been working on this event for 3 months, probably 3 or 4 months, between invitations, sharing the book, and so on. So again, thanks again on behalf of Verónica, because she tried her, so I want to insist on this. She sent me a message early in the morning. She was going to make it. We planning not to do a video recording. So again, thank you very much. William in particular, Iain for organizing this, Marichui, my friend, for organizing as well, Andrés, Imer, and Herlinde, because we are making it possible. Without any further ado from me, and Marichui, if you have a problem with the sound, please let me know, and I'll try to fix it. I would say I want to say this, I know you're English, I want to say this, you're my favorite legal philosopher, male in the UK. It's honestly, I'm not British, I'm being honest here. So Professor William Lucy from Durham Law School, and he will be commenting chapters 1 and 2. Thank you very much.
Thank you, Jorge. That's a very generous introduction. I'm hoping everybody can hear me. It's the person speaking is this person who's waving their hand around on the screen. I'm just looking at the screen there, so hopefully
Yeah, they can hear,
everyone can hear, and we'll get the sound at this end sorted out. And it's lovely to see some familiar faces. Hi, Imer. And lovely to see so many people from so many different places. The brief for this talk, although Verónica isn't here, I'm going to stick to the original brief, and the original brief was to offer some comments for 10 minutes or so. I'll try and stick to that brief. I'll set my stopwatch and see how we do. And 10 minutes suited me, given that I was going to look at chapters 1 and 2 of Veronica's marvelous book, because for my purposes, if I were to try and make kind of critical trouble for Veronica, if she were here, I think the only kind of critical trouble I've got is in chapters 1 and 2, and I think the issues, just about all the issues I've got would arise with regard to the discussion in chapters 1 and 2, and there are only 2 issues. So let me start my stopwatch and tell you what the issues are. So here's the first one. It seems to me that the contrast and the puzzle that Veronica sets up at the beginning of the book in chapter 1, the contrast and the puzzle between what she calls the first person or forward-looking perspective and the second or third person backward-looking perspective might not be perhaps as puzzling for us in general. I'm leaving lawyers out of it when I say that, as Veronica might want it to be. So it might not be the challenge that she sees it as. My point, however, might be entirely consistent with what Veronica subsequently says, because she tries to marry those 2 perspectives, the first person forward-looking perspective as against the second or third person backward-looking perspective, tries to marry them by an argument about change of aspect, and says that they're actually combinable. This is the duck-rabbit image that she takes from Wittgenstein and uses to good effect to marry 2 supposedly incompatible perspectives. So what I'm going to say now is, I'm not so sure that those perspectives are incompatible, or perhaps I'm actually saying that we might not need one of them, the second and third person perspective, in the form that she presents it, as a really big contrast between the first person perspective. And the reason I'm going to say that is because I think either we don't need that third person perspective unless we're in the courtroom or something like that, or, well, we don't need it unless we're in the courtroom, and we don't need it when we have an audience to our shortcoming. And I'm going to use the phrase shortcomings, Tony Honori's phrase originally. I'm going to use the phrase shortcoming and the phrase shortcomer to refer to somebody whose conduct falls short of a standard, whatever the standard might be. And I'm going to give you an example, which I think is perfectly intelligible to us all. and by intelligible, I mean we can understand it, and it's also normatively intelligible. And it's a scenario in a story, perfectly mundane, quotidian story for us. And it's a story in which we're able to make ascriptions of liability, responsibility, I'll use that kind of Hartian phrase, without having any big problem with the supposed puzzle of the first person forward-looking perspective and the second person, the second third person backward-looking perspective. So here's the scenario. And it is perfectly familiar. We've all been here in one way or another. Let's imagine we're at a football game and the participants are there doing their thing, and we, the spectators, are there, and the coaches and everybody else are there. And the team in attack has a particularly promising situation in terms of attacking play, and we, the crowd, and everybody else observing this, can see that the ball is played forward to an attacking area, that our striker, whatever he or she's called, has got into space, has evaded the defender, is in a position where it's really relatively easy to score. One-on-one with the goalkeeper. Let's assume the goalkeeper is out of position, and our striker shapes her body or his body to blast the ball into the net. But what happens next is that the ball doesn't go into the net. It bobbles off the striker's foot and goes out for a goal kick. And we, the second person folks here, do exactly the same thing as the first person, the striker. He or she collapses to their knees, holding their head, yells, more often than not, "Oh God, how did I miss that?" We in the crowd are doing exactly the same thing at exactly the same time. Moreover, in the crowd, we'll appreciate that
Apologise. The problems are there, and if you can't hear them, don't listen. That's your help.
right.
Your mic's working. So it's there.
Maria, could you just say something for us?
Hello?
Tell us what you had for breakfast. Okay, that's very quiet.
Yeah, which is fine.
Can you hear William?
Yeah, it's perfect. Yeah.
You can hear me.
Yes, yeah.
It's working here as well. Thank you, Marichu. It's working here. Thank you. Sorry, people. Thank you for your understanding. We are philosophers here. Yeah.
Sorry, let me just let's start. So actually, well, so here's the thing. Here's an instance of shortcoming that's unfolding in real time, and we've got the agent's conduct and the agent's assessment of what happened there, and our assessment of what happened there, and these are kind of unfolding simultaneously, and we all know what's gone wrong here, right? And our reaction in the crowd, we say things to the footballer like, "You're better than that. Oh my God, how have you missed that?" He or she is saying exactly the same things. "Oh God, I'm better than that. How could I miss that?" And we all know at the time this event's occurring what's going on, I say, and it's perfectly intelligent. And also in this example, I do not think we have a big problem with combining first person perspective and second or third person perspective. Because when we're in the presence of shortcoming, when there's an audience, when we're in the presence of shortcoming, there isn't a problem, it seems to me, generally, when shortcoming has an audience with first, second, and third person perspective. They're all combined. We all know that this was a chronic miss by the striker. We all know, without doubt, it was an instance of shortcoming. And And he or she does too, because he or she doesn't walk away from the missed opportunity with a smile on their face. He or she is holding his or her heads in their hands. He or she is utterly shocked by what they've done. And so on. But so far, I think, so unproblematic, because what we're going to say as crowd and what the player's going to say is, normally, I'd score that opportunity. Normally, that's an opportunity that I take and succeed, but this time I've missed it. So we make judgments about what Honori calls can general and can particular. When we're thinking about the capacity for human agents to do something, they can have the general capacity to do something, and the general capacity will tell us about this particular footballer that in 8 out of 10 kind of opportunities like that, they're going to score a goal. And if that's true of our particular striker, then we're quite content, as he or she would be, in attributing some degree of liability responsibility. We're going to blame them for missing this opportunity, for this instance of opportunity. And we blame them even when we encourage them, because the standard call from the crowd and the terraces there is that one I gave you not long ago. You are better than that. It's meant to be an encouragement. You are better than that. It's an encouragement to say, next time you'll take the opportunity. We all know normally you would do that. We all know normally you would score. And the judgment there is between can general and can particular. So whatever's happening in that story, and I think it's a quotidian story, because we can apply it to when we drive our cars into other cars, when we drive through traffic lights and so on and so forth. We say the same thing. The bystanders, when I drive through the red light on Oxford Road here and hit the bus, know exactly that what's going on there. It doesn't seem problematic. This is an instance of shortcoming. The scenario is not problematic if I'm conscious in a non-autonomous state and generally able to drive. In this instance, there's an example of shortcoming. I've fallen short of the standard, and it seems to me, I myself will say, oh my God, what was I doing? Bystanders won't say, as in the football example, you're better than that, but they'll assume I'm better than that if I'm legally entitled to drive. They'll assume that, generally speaking, I drive my car around without smashing into pedestrians and buses. So I have the general capacity to do that thing, and in this case, I've fallen short. So here's just the question then. I don't see the problematic. I don't see that there's a problem in that kind of example with the first person forward-looking perspective and the second or third person backward-looking perspective. I think the perspective I've given you there, which is a standard Honorian account of how outcome responsibility works, seems to be immune to the puzzle that Veronica starts off with and sees her account as an effort to solve. I've no doubt that she solves it, and the recourse to Socratic judgment and her Aristotelian account of deliberation. All that is absolutely fine to me. I guess what I'm questioning here, just at the outset, is that puzzle, the puzzle between the first person and second or third person perspectives. Why is that really a puzzle? Now, it seems to me the third person perspective can come into play subsequently, and it's the kind of perspective we associate with lawyers, right? And lawyers, when they're thinking about, for example, why the striker failed to score the goal, it would be the pundits on the Monday Night Football show, right? We'll forensically examine this miss, and they will have camera footage of the striker and the ball bobbling off his or her shin, and they'll look at it quite deeply. I'm not sure they'll be asking themselves what the striker intended to do at that point, or even whether there was a lack of intention, with regard to that particular result or outcome, and I accept the complexities about results and outcomes. What they'll be looking for is an explanation of that, but the explanation was available to us all there at the time. It bobbled off his or her shin. That's the explanation. You weren't paying attention when you drove through the light. That's the explanation, right? And I think that explanation in itself may well be complete. And we don't generally have a problem with its normative standing either. Because if you can generally drive, and if you generally score opportunities like that, we, non-lawyers, are quite content to make liability responsibility judgments. It's to your credit when the goal goes in, it's to your discredit when it doesn't. Okay, so that's my first point. Is that contrast as significant or as important as Veronica says at the outset? Again, I think practically speaking, it doesn't make any difference to her argument because none of what I've said so far undermines anything she says about Socratic judgment and her Aristotelian account of deliberation. My second point is that example that I started with, which I think undermines the significance of the contrast between first person and second or third person, perhaps even just sets that issue aside. That example is an example of what Tony Hanori characterized as outcome responsibility. And I think we can begin our thinking about shortcoming, as Hanori suggested, with the idea of outcome responsibility. And my second point, as against Veronica's argument in the book, is that I think Hanori's work should be front and central in any discussion of shortcoming, in any which will inform a discussion about the law at some point, or negligence, right? But Hanori's account of shortcoming and capacity is a general one. He is not initially interested in law at all. But I think that account of outcome responsibility should probably be our starting point. And it's a starting point that seems intuitively, commonsensically, perfectly plausible if you buy what's going on in my footballer example as being normal, commonsensical, and usual, right? And so here's a complaint. I don't think the notion of outcome responsibility, although Veronica talks often about moral look, and the notion of outcome responsibility is clearly attached to that, I don't think it gets sufficient attention in the book, and I don't think Hanori gets sufficient attention in the book. There's a few pages, page 156 onwards, where he crops up, and then in chapter 9 and a bit later, Hanori gets positioned alongside John Gardner as a corrective justice theorist. But I don't think that's an accurate account of Hanori's view with regard to the normative structure of tort law. If anything, he's a mixed theorist in the sense that he thinks there are numerous different conceptions of justice in play in the substance of law. Of course, we might say he's a corrective justice theorist in another sense, but he's not a corrective justice theorist in the sense of what he takes the normative content of the law to be. He thinks the law is mixed. There are different notions of justice in play in this area of law. He could be a corrective justice theorist in the sense that all corrective justice theorists cleave to or hold on to the notion of outcome responsibility. But I think that notion stands independently of any particular argument about the nature of negligence in tort law or anything else. And I think the argument about outcome responsibility and the characterization of it is a general application. Whether or not it works out in the law of negligence, I'm not particularly worried about, because one thing I know about the Anglo-American law of torts is it's a rag bag of stuff. It's the product of many minds working over, well, just over a century with regard to the tort of negligence, resolving particular cases. And were this area of law to embody a coherent moral blueprint about precise philosophical account of responsibility, if it were to embody that, I'd be quite surprised. As Professor Unger said a long time ago, it looks like a daring and implausible sanctification of the actual, assuming that the law embodies a neat philosophical account of responsibility. I think it's consistent with a neat philosophical account of responsibility that we call outcome responsibility. This is quite different account of responsibility to many of those that are available to you. And Veronica, if you were here, unleash the guns on me, please, because that's all I've got to say. Otherwise, I've got nothing to disagree with in the book.
Thank you very much, Prof. Yeah, thank you. I wonder, your first distinction, whether that's structural, but I get to learn, from Imer and Andrés and Jorge. Thank you very much. And now we have our second commentator, Imer. ¿Estás ahí?
Yes,
I'll do your introduction. Professor Dr. Imer Flores, from Instituto de Investigaciones Jurídicas, Universidad Nacional Autónoma de México, chapter 3 to 5. The floor is yours. Thank you very much. Gracias.
thank you, Jorge. Well, congratulations to Jorge, to Marichuy, Iain, and all the friends in Juris North for the opportunity, and thank you for the opportunity of participating in this monthly discussion, along with good friends like William, Andrés, and Erlen. And especially to discuss Veronica's book, which I think I agree with what William just said, that she seems to be in the right track for something. I'm not sure exactly what she's for, but I see a lot of things. I'm very empathic on the project, and I think that will be a nice contribution to the fields both of moral philosophy and legal philosophy. But of course, I would like. I'm not sure. It seems that Veronica is not here, although there's someone with the name in the Zoom of Veronica only. But I will. If possible, also I would like to, if I got her correctly, and right and so on. I have the feeling that she's becoming a fellow hedgehog. Somehow I always thought that she was a fox, but now, if I got her correctly, it seems to be coming to a different approach or a different idea, which basically is as William was saying, trying to make sense of what we do and how she somehow describes and re-describes. And she focused on the problem of negligent acts, which have this kind of paradox that how I'm supposed to be responsible for being responsible. And what I have to figure out is that you were supposed to be responsible and we are holding accountable because of that failure. So the book is, and I will try to make this general comment and then go more to the chapters 3, 4, and 5. So she has a very key concept, which is the gracia, and I know that will be Andrés' turn to emphasize that. But basically, she wants to make room to argue that when the performer of the action deliberates and knows what to do, but decides to ignore her own deliberation on the matter. So she seems to be trying to push the idea that we are always deliberating, and somehow that we are also responsible for our failures to deliberate. And as William was saying with his example of the soccer player, you're better than that. We always claim something like, you know better, or at least you should have known better. We're expecting something more of you. So I think that somehow she's in the right track of trying to understand what is going on in these cases, why we are holding people responsible for these negligent acts or for these reckless acts. They were in error, they were mistakes, they were so I think and I agree also, but and the book is, let me suggest that the book is full of distinctions, internal external reasons for actions, beliefs and desires. One key concept which I think is very important to understand her is the synchronic and diachronic. She seems to suggest that whenever we think that something is synchronic, keep in mind the picture, the photograph, and it's like static, and it's not a good idea of how we deliberate, but more into the chronic. So she's, and I think that's why she's very interested in the first person. How does the movie video of the first person, where we start and where we end, rather than just taking like the snapshots of you were responsible because of that, or you were responsible, but how we transform. That's the word she uses a lot in the book. I am not sure that's the best word I like. That's in the sense that we are always transforming ourselves. I think it's not that strong. I think a better concept is already in the book in the later parts. She comes with a purity, and I would like to emphasize a little bit on that concept. So now how we become mature, how we and that's getting closer to the points of the book. And so as William was saying, I think I also agree that the backward looking, the forward looking, it's not necessarily doing the trick for her here. I think the trick is because it's, from my point of view, is more of going back and forth. And I can see that being also bottom up, top down, backward, forward looking. So I think we are always measuring ourselves against something. So as William was saying, we are supposed to be better than that. So measuring our actions to our better version, even though we don't know which is our better version of ourselves. So we have not form of selves to mature within our own experiences. And if my feeling is that sometimes people have grown because of being exposed to different moments or different facts or moments, and other people who have not that experience, who have not this ability of growing, of becoming something, of becoming a better version of themselves. So let me just add to the idea that what does the trick for Verónica, and that's one of the points which I think that's what she wants to do with the insistence on the first person perspective. I think that the second and third might be a distractor, is that even the first person has to and the dog rabbit, Wittgenstein dog rabbit example is very helpful. We have to see an aspect, but we can see another aspect. So, and I think that's starting to make the trick. Somehow she wants to integrate the different the beliefs and desires, and I will go into why she criticized the balancing model soon. So just one thing, that dog rabbit example is very helpful to emphasize that we can see one thing, but that we can see another thing. So I think that part for Verónica works, because she wants to make the point that the first person is seeing something, but she can see something else. And clearly in the dog rabbit example, we can see either one or the other, but that because that's wrong. But in her position or in her idea, we can see all the aspects, not only one or the other, but all the aspects, integrate all the aspects. So William didn't mention the case of Alexandra. That's the lady who left the dog on her vehicle on a hot day, and she went to pick her children. When she returned, because they got delayed, they got stuck in, they returned to the vehicle. The dog had died from a heart. So I can see that in this idea of seeing different aspects, we can see how Alexandra should have done something very different. And we can go into hypotheticals, counterfactuals, and so on. And that's why we measure ourselves, like making room for a better option. What should I have done? What is the better option? And again, following William's example of the football, oh, I am better than this, and I can do something, and I think that's what she's doing, and I think the criticism is right that she might be more explicit in emphasizing this, but I think that she's right. So also she's very interested in responding to the skeptical views that people are not responsible for negligent acts, and I think, as William pointed, I think we know that we are better than this, so we can be measured to the or better option, to the better version of ourselves. So basically in the chapters 3, 4, and 5, so sorry for context of the book, but I think it was necessary to get into these precise points. She seems to challenge, or she challenges the bifurcation thesis. She sees like very predominant in the literature, the bifurcation between desires and beliefs. And so the idea there is no interaction between them, that either we are motive-based or reason-based. And of course, she wants to make room to the interaction between those of them. And it's curious that in the literature, this is somehow called, or so-called, the balancing model. Arguably, we are balancing desires against beliefs, beliefs against beliefs, desires against desires. But from my point of view, we are really not balancing anything. And I think I would probably like to stress Verónica, or to push Verónica forward into being more clear on the piece. People merely choose to go for the motive or the reason or the desire or the belief, or this belief instead of this other, or this, and I have the feeling that we are failing to balance them, to truly balance them, integrate them, which, as I said, I think that's if I'm getting Verónica right, that's a very project. I think that's very close to Dworkin's defense of the unity of value, and so to the criticism of this balancing model, which doesn't balance anything. It just tilt the scales either side, but it's not trying to figure the correct balance between different actions, and it's not moving forward to a better version of ourselves. So as I said, this and William also pointed out, she labels this an Aristotelian inspired model of deliberation and practical reason. I am not sure if we have to stick to the Aristotelian part. That's being only Aristotelian. I think that might be misleading, but I will take her for her word. She wants to call it Aristotelian inspired. I think there are a couple of very nice passages, these chapters, in which she emphasizes that remember Plato's dialogue, Protagoras. The Protagoras, the discussion between Socrates and Protagoras, the main part of the discussion is whether virtue can be taught or learned, or it will be something that can be only acquired. So this kind of, if the idea that Verónica is trying to push, it has to be both. And I confess, I read that piece many years ago, and I haven't never thought really how much they can collide into one version. I always thought that paradoxically Protagoras and Socrates shifted the roads, but probably they were both getting into an integration of the two positions. So I know I have to reread that and have a much better idea of if that sounds. But anyway, what I think she's trying to, that's why she goes and traces Acrasia to the ancients, but she also goes to Acrasia into the moderns, and somehow she wants to make the claim that Aristotle was the first that did get this integration. But as you know, Aristotle is also famous for the distinguishing between reasons and emotions. So I am skeptical that label is the better one, but I can see the idea that she has in mind, and that's more clear in the chapter 5, the deliberative aspirational perspective, which she calls upward. It's not that there is not notice that this also reminded me, for instance, of Lon Fuller in the distinction between the duty of the reference to the duty of aspiration, which it seems to be like it's getting. Fuller puts it in the top-down way. The aspiration is in the top, and you have to reach the top. But and somehow Verónica wants, and I think that's the right way to understand this. We want to go all the way up. We have to start in the bottom. We will be moving. We will fall. We will grow. We will not necessarily realize that we are growing. We will have failures. We will have to go back and forth. We will have to. So in that sense, I completely see why she ends up with the idea of that being something upward, because she's getting the feeling that it has to be some sort of improvement, some sort of growing, some sort of becoming a better person, becoming good. That's one of the subtitle, the chapter title. So I think all of this, from my point of view, makes a lot of sense. I agree with William. Probably I'm getting her wrong, and then she can come hard to me. But I think it's a matter of fine tuning some of the ideas and to be more precise on some of them. And let me just to conclude, let me just say something that I think, and that's why I enjoy very much the book, and I think it will be very helpful to understand a lot of what is in the literature. And I'm coming more from the legal philosophy more than the moral philosophy, but for some of the interaction between moral and political philosophy. And so let me suggest that this idea of the she seems to be calling it forward-looking, to be onward. I think it goes back and forth. I think it lies growing and sometimes failures and successes. But let me just, and that will be like my question to Verónica, because I have the feeling that there were parts of the literature which I think are very relevant to the project, and at least, for instance, I think of Isaiah Berlin. I think, for instance, of Fuller, I already mentioned. But let me point some of the ideas that I think that are underlying her, and I think she will. If she's not engaging with ideas on the book at the end, we can then engage on those ideas, because I think that's the contribution of the to bridge some of these. So I think she provides a better understanding of John Rawls' reflective equilibrium, the idea of public reason, and in Rawls' terms is the duty to civility. In Verónica's terminology, she called it maturity. So in this process of becoming a better person, a more mature person, I think that's part of the. So I think what she seems to be thinking of forward looking. But anyway, I also think that, for instance, Hart's critical reflective, Ronald Dworkin's Protestant attitude, even Walushow's engagement with the ideas of Rawls and Hart's and Dworkin's on this idea of how we hold people responsible to the true beliefs and commitments, and that the whole case of judicial review, and why I think it is important to make people responsible for the negligent acts, because they were supposed to we were expecting. We know that they are better, and we were expecting them to be much better than what happened. And again, it has been a pleasure to comment on Verónica's book. I really think she's into something big, as always. I have the feeling that, or probably I didn't get completely the idea, but I think I think she's in the right track, and I'd like to push her with some of these complementary notes, probably footnotes to her project. Well, thank you all.
Thank you very much, Imer. Gracias, Imer. Un placer. Funny, Marichui already made clear for people here as well in person. A question to be taken later after all four comments. Thank you very much, Marichui. And I can see one of the questions, my brother, gracias, Emil. Because I shared the book, Verónica very kindly let us share the book with those who book place here, and we were talking about something that Imer and with my family, we are three brothers, all of us lawyers, and my brothers do private law too. And we were talking about, exactly the points Imer, weeks ago, and William are raising now, whether there is, an issue that goes throughout the chapter. Gracias, Emil. Well, sorry, that's a personal comment, the family comment, because we talk about, knowing the family as well. Now we have Andrés, ¿estás listo? Perfecto. Our friend, Professor Dr. Andrés Botero Bernal from Universidad Industrial de Santander, Colombia. Chapter 6 will be having from Andrés. Pleasure, Andrés, and we can hear you now.
Okay, thank you very much. Could you hear me? It's very good, isn't the sound? Okay, perfect. We can begin. Well, hi to all, hi everyone. Thank you very much, Jorge, for this invitation. And thank you very much for Verónica, because her book is a very, very great book. And I would like to talk with you about the chapter number 6. But I need to begin with any accuracy. My oral communication tools are not the best, excuse me, are not the best. So I prefer to read with my funny Latin American accent, my participation in the excellent book of my dear friend and colleague, Verónica Rodríguez. Well, let's start then. I could share the document, I suppose. No,
let me give you just a sec.
Please.
Yeah, you may now, Andrés. Yeah, you should be able.
Okay, perfect. Let me. Could you see my text?
Yeah, perfectly well. Yeah.
Oh, okay, perfect. But I suppose it's very grosser. Well, I have read and I have also translated into Spanish, thinking in a future publication here in the Latin American culture, the chapter 6, taking acrasia seriously, which is subdivided into 3 sections: the ancient versus modern view of acrasia, the contemporary conception of acrasia, and acrasia as a failure to transform and integrate desires, emotion, and thinking towards the aspirational deliberate perspective. This chapter is very interesting because the author researched from many variables and hypotheses the relationship between acrasia and responsibility for negligence and ignorance. This leads the author to reflect her ideas on several fronts with great skills. 1, does all negligence morally and legally can fit into the concept of acrasia? She is skeptical in front of the traditional Platonic model, which leads her to rebuild from Aristotle a new model. Second one, the response to that this dilemma is necessary to clarify the concept of acrasia. As the analytical philosophy will say, Clariffius concepts resolve false dilemmas. But as the concept of acrasia is historical, it is necessary to ask for the meaning of this concept of its context of creation. Ancient Greece, in its development context, Middle Age, and in its current application context, contemporaneity. The author concludes, without surprise for the historian of philosophy of law, in my case, that the meaning of the concept has mutated in these 3 contexts or scenarios, which seems clear to me because there are no timeless concepts. And if there were, they would be concepts unrelated to culture and with men. However, the author dedicates a good number of pages to analysis from the Greek light, contemporary problems of moral and legal responsibility. This led to me a doubt. which will certainly have a valid response, but this is not expressed in the chapter. If the acrasia is different in the Greek world from the contemporary, why leave from these Greek authors for the practical conclusion to which arrives today? Now, I think that historical tracking that the author makes is very important so that the reader doesn't believe that this concept has been unscathed through the times. Here, I see the need to clarify a specific aspect. The author repeatedly alludes to two engines of acrasia in ancient Greece, Socrates and Aristotle. What I consider is a minor error, but an error. Of Socrates' real, we know almost nothing. We only have some approaches from the works on 4 disciples, but the acrasia is especially development, but one of them, Plato, in one of his dialogues, Protagoras. This dialogue, although it was made in Plato's youth, it's still the expression of Platonic thinking rather than the Socratic point of view, of which we do not know much. I will say that there is a certain consensus in the contemporary Platonic that these concepts, even in Plato's first works, although they can have a story in Socrates, they are more Platonic than anything else. I reiterate that there is no way to demonstrate that these Platonic concepts, like acrasia, are from Socrates. Plato, despite his relation of poets, is a creator. And science, we don't really know that Socrates says. It is easier to think that allusion to his master in dialects are a literary research. Therefore, in both, I would prefer to refer to acrasia as a Platonic concept rather than Socratic. I know that time argues, so I have 2 specific comments here in front of his chapter, specifically in the 6th chapter. The first one has to do with the assumption of the analysis of acrasia. Acrasia will mean the erroneous exercise of a moral agent that, without intentionality seeking an incorrect result, produce it. Of course, this definition is very wide and deserves many nuances. However, it serves for a moment. Acrasia thus supposes a complex relationship between knowledge, knowing if something is wrong or badly, morally and legally, and desire, passion, when in case of not being controlled, it leads to immorality and, therefore, to a moral and legal responsibility from the agent. But this scheme, which comes from the Greek word, part of a separation that is doubtful, reason and passion. The Professor Imer Flores says something very interesting about this. Greek philosophy considers that reason must control, not distinguish, passion to give rise to the correct behavior. Now, this duality, without which acrasia will not be understood, has many contradictors, which we can divide it into 2 groups. But this is a division, artificial division, but it's very important to say it. The first group are those that argue that reason is a slave to passion. So that morality and immorality is a passionate issue where reason can interpret it, but not rules. At most, reason can correct certain long-term aspects, but it is not the engine of morality. Here we find authors such as Hume and Schmidt and Schopenhauer, of many others, and Schopenhauer through the letter with some nuance. The will, for Schopenhauer, as support of morality, goes more through the passion than for reason. In this case, the way of understanding acrasia changes radically and therefore the moral and legal basis of the responsibility of negligence. This is something that is not analyzed in this chapter. The second group are those that argue that the separation between reason and passion is artificial, but not real. Consequently, what we call reason is a special type of passion, or vice versa. That passion is a special type of reason, but they are in the same set, which are similar and not opposite concepts. Many neuroscientists and neurophilosophers think in this way. Thus, when the reason faces a patient, it's really a patient that controls another patient for some, or a struggle inside reason for others. This position will change, I think, the author conclusion. My second comment is that the author tries to expose the largest number of possible accretion and negligence events. There are many variables that she analyzes to conclude rightly that easy answers are wrong. At the end, the author is inclining to an answer that there should be no opposition between knowing and acting, because who knows the goodness of evil or an act. If this person develops an adequate deliberation process, must change his behavior and modify the passion in the sense of deliberate. This will solve many problems of considering that accretion as the basis of responsibility. Part of the separation between knowledge and application, between reason and passion, between deliberation and desire. Who knows well, behaves well. In a sense, it is an innovative reconstruction of Platonic and Aristotelian thought, reason as the necessary foundation of the action, the legal and moral action. However, as is clear in this chapter, there are so many cases, so many possibilities of action, so many situations, so many types of moral agents in the accretion, which is very difficult to reduce so much complexity to a few options. For example, how universally determined that an agent did not know where and therefore did not act well? In addition, how to know that this was deliberated well, if this trial also involved passions? That is, knowledge is not only rational, but also passionate. Then we are facing an ultra-complex system where to know and desire intermingle from the beginning. Desire more knowledge, knowledge regulated desire. Who is cause and who is effect? To this, I add that there are always limited cases. The author, the Professor Verónica, recognizes that the type she analyzes are ideal and that gray abounds for the cases. But if what abounds is gray, how to affirm something so clearly? Maybe the answer is, I'm not sure, I'm so sorry, following a teaching of Aristotle, the concrete, contextual, or circumstance action. Each case will be a word. We share some things with other case, which will adults are certain generality in the trials, but never are applicable response to all, maybe not even to almost all. Now, finally, I would like to praise the author for the following reasons. 6, to relate philosophy to morality and law, as well as the concept with their context, and does so with great rigor in its sources and interpretation. This rigor left me presently impressed. Since I am philosopher, historian, and lawyer, these chapters renounces anacronyms and fragile interpretation of many legal texts. This chapter is very good in this point. Another reason for praise is that she realizes that the cases are so many that a uniform theory is not possible. Although it does not give up preparing a proposal that resolves most of the problematic case around moral and legal responsibility. She accepts complexity, and instead of being scared, she faces it, trying to unravel the estranglement in which we are when we ask why judging who behaves negligently or from ignorance. The author is not intimidated in this text. Congratulations to the Professora Verónica. It is a great text. Well, I finished. Thank you very much for your passion.
Gracias, Andrés. Thank you. And don't worry about your accent, I'm not Mancunian. I have accent myself, very clear. Thank you, gracias. And now, my pleasure here, welcome to Professor Dr. Pauer-Studer from the Department of Philosophy, University of Vienna, and Chapter 7. As we can gather, we follow the order, so that's why last but not least, Caroline, your floor now.
Okay. Well, hello to everyone. First of all, I would like to thank the organizers for inviting me to comment on this book. I think it's an absolutely impressive book. It has really detailed discussions about responsibility in ethics in law. It's also a detailed discussion about practical reasoning and practical reason. And also about our self-understanding of agents and how we situate ourselves in society in a legal perspective, but also in a moral perspective, right? Now, my task is to present Chapter 7. And this Chapter 7 is really about different accounts of private law, tort law, negligence law, and it prepares the ground for the last two chapters, where particularly Chapter 9, where Verónica then talks about the role of judges and courts and the interaction of the judges with the defendants in light of the plaintiff's claims, right? And it's also really, the book is addressing the issue of how we construct a interpersonal moral structure that underlies a well-formed, a well-ordered society. Now, about the Chapter 7, as I said, it shows that contemporary general theories of tort law, they fail, and they fail in regard to 4 requirements Verónica has outlined, and she outlined those requirements already in Chapter 1. And the 4 requirements, she calls them 4 challenges, are the abstract challenge, the particularity challenge, the deterrence challenge, and the guidance challenge, right? And I would like just to give a very quick definition of those 4 challenges, and before I go into her discussion of the various theories. So the abstract challenge is merely that all theories, she claims, that focus on the pairs or the concept or use the concepts of rights and duties, right, to account for the relation between the plaintiff and the defendant. She thinks these accounts don't really engage with negligence, right, or not sufficiently. Why? Because they rely on a very abstract conception of action, and they also leave, she argues, obscure the real responsibility at stake, right? Why we put blame on someone acting negligently. And she also says all these theories have the wrong account of deliberation. This was addressed before. She defends this deliberation aspirational conception, right? And she criticizes and rejects what she calls a balancing, a weighing model of reasons. The deterrence challenge is the second requirement. And here she argues, look, deterrence should be conceived neither in terms of a mere empirical engagement with what happened, nor should it be tied to risk. And here she criticizes really the assessment of risk, which is often done in trials and court proceedings on negligence, because she argues these are very abstract concepts in terms of probability assessments that don't address what's going on the level of the practical reasoning of the negligent agent. And she also, which is interesting, I come back to this, she rejects that deterrence includes anything or is tied to anything like pure coercion. The particularity challenge, the third challenge, conveys the idea that engaging with a negligent action on the part of an addressee of the law, this cannot be articulated from the point of view of general rules, principles, directives. This is tied to what was discussed before, that she is skeptical toward a third person standpoint. And the last request or challenge is the guidance challenge that establishes that an adequate theory of negligence needs to explain the way how law engages with the practical reasoning of the addresses of the law. And this is tied to the picture she develops later on, that she really thinks a lot about the interaction of judges, courts with the defendants, and she thinks they have to pay attention to what is going on the level of deliberation of the negligent agent. Now, she then addresses prominent accounts of tort law, and she distinguishes three main directions: person-centered theories, aim-centered theories, and theories that sort of advocate a kind of continuity between the ethical and the legal. Now, I would like just quickly to focus on the person-centered theories of negligence, particularly here on Weinrib's and Ripstein's account, right? They focus on what we can do, and these accounts, the person-centered, focus on the persons, right? And Weinrib and Ripstein famously use a Kantian framework, combine it with a relational conception of morality, but also of law. And at the center of that relation is the concepts of right and duties. So if you violate your duties towards a right holder in negligent acts, then you are, famously, Weinrib argues, then you have to compensate this. And this is a matter of corrective justice. The aim-centered theories of negligence, they focus more on the aims of the legal aspects, the legal machinery. What do we want to achieve in jurisdiction? What should judges aim at in dealing with cases of negligence? And the last theory is this continuity, and I leave those aside. Now, her critique is that the aim-centered theories of negligence, they just focus on the general purposes in tort law. They miss the person, and I agree here, right? Because negligence really has to do a lot with the relation between the defendant and the plaintiff. What did the defendant do? Why has the plaintiff a right to morally blame the person and has a legal right to compensation in terms of corrective justice? Now, when she comes, I think everything she said there is completely plausible. I'm less sure about her critique of person-centered theories of negligence, particularly her critique of Weinrib and Ripstein, because they use a Kantian framework, right? And this is important in the following respect, because and I go now into a critique and my first critical comment, right? Why am I skeptical here? Because as you can see in Veronica, you have herself, she falls into the theories that advocate a continuity between the ethical and the legal. She has no strict separation between ethics, interpersonal morality, and law. Everything smoothes into it. And in a Kantian framework, and I think Weinrib and Ripstein pay attention to this and are here very careful, you have to keep separate the legal aspects and the moral aspects. But if you express it, what's going wrong here in a relational way, right? You still take the persons into account in their rights and duties and what harm has happened to them. You take the person's perspective seriously, but you don't commit the failure of a complete fusion of law and morality. I would like to cite here what Arthur Ripstein says in his book, Private Wrongs, right? The book is here. It's really, Veronica's critique is very important, but also Arthur's book is important. He says, interpersonal moralities requires institutional instantiation in a body of positive law. So the idea is, when you take the Kantian framework, you have ethics. Here you have all the ethical considerations the person has, and we expect the person to be critical to herself, himself, themselves, right? Interpersonal morality, here you set up principles of justice, right? And you are already on a social level, and Veronica brings this out very nicely in her discussion, inspired by Wittgenstein's, I think, objection against private language, that justice is something public, right? And we have to go here public. And interpersonal morality, think of Rawls, is addressed to institutions, and we are here in the public sphere, right? And when Ripstein says it requires an institutional instantiation in a body of positive law, I think this is really important, and therefore I cannot really accept or think so. I don't think it's so plausible what Veronica criticizes, what she calls the abstract challenge, right? And also that we should not merely, or the particularity challenge also, that we should not try in negligence law to come up with strict rules and with directives or principles. And I think this is wrong. Why? Because negligence, the issue of negligence, is a matter in criminal law and it's a matter in private law. Now, criminal law, there the state comes in, the state prosecution comes in, and the defendant faces, if the defendant is sentenced, not only a compensation in terms of money, the defendant faces prison, right? So this is really coming in the form of state coercion, and we cannot simply leave matters there to a moral dispute among judges, right? We need here statutes and clear rules and standards, and those standards exist. Now, I think something similar has to hold for civil law and negligence in private law, right? We cannot leave it to the judge, right, to reason here merely from an ethical perspective and address the defendant from there. Why? Because how can we exclude arbitrariness here, right? How can we exclude that the judge has a particular, maybe prejudiced conception of ethics, of what is correct, right? So we simply need some rules and standards also there. And the third worry I have against Veronica's approach, as important as I consider it, right, in terms of her ideas on practical reasoning, which really enrich discussions of practical reasoning and deliberation with respect to ethics and morality. But I'm a bit skeptical here, and my worry is you need a clear separation between law and morality, because otherwise, right, you will have institutions of the state, and a court is a state institution, whether the court deals with private law issues or criminal law issues, it's a state institution, and we simply don't want the state to enter all of our personal reasoning, right? And the state has the right, and courts have the right to tell us, right, you acted wrongly, right, and therefore you have to pay or compensate damages, or the state may, even if it's a case of criminal negligence, tell us you have to go to prison, right? We still don't want the state and the state institutions to come in and moralize in a moralizing way, occupying our innermost convictions. And I think that the basic message of Immanuel Kant, right, what he tells us, that the state coercion is limited, and it can't have access to our innermost personal freedom. Now, just a last point, why I think that Veronica doesn't draw that distinction clearly is also obvious in her examples. The case of Alessandra was already mentioned, Alessandra leaving the dog in the car, right? Imagine it would be her baby or her child, right? All these cases also happen. But if she leaves the child there, it's an issue, it's criminal negligence, right? And the examples are a bit ambivalent, right? It's not merely a moral failure, and what he needs to understand is that the offense and the deed and the action is so gravely wrong that really the state comes in the form of maybe of coercion, right? But on the other hand, what I find so absolutely fascinating about Veronica's book is that she really wants to give an account and situate law in a certain space where we are part of society, and the institutions, the legal institutions, have to take us seriously as persons, how we interact with each other, how we interact with ourselves, and whether the state and the courts representing the state, whether private or criminal law, have to tell us, give us messages and inform us also about the standards where we have gone wrong. But those standards have to be articulated clearly in kinds of either statutes when it comes to criminal law, or in clear standards when it comes to private law. So thank you a lot. I'm at the end of my comment.
Thank you. Sorry, we were muted. Thank you very much. A pleasure, family. We were clapping here. Thank you very much. I think we have a question, Marichu. Before we finish, I'll try to wrap up, and I'm going to go backward. But I think to see a common thread in all the comments, and I read the book myself. I'm going to start with Herlinda here, and I'm going to paraphrase. How can we exclude arbitrary interpretation, arbitrary decision making, arbitrary law making? And here Herlinda brings a point that again I see in all comments. The fusion or non-fusion, this interpersonal sphere between the ethical and the legal. And it has to be with the lack of discernment between these different. I think probably that's what we are missing in this book, you know, a bit more assertiveness in the sense we discern the ethical from the legal, although they may be related. And probably that comes from the other chapters, because again with Carolina we have chapter 7. But we got the same issue, Andrés clearly pointed out, the lack of extension of the mixture between reason and passion. That's exactly the same criticism we have with Rawls and his theory of justice. Why I'm saying this, because I use Rawls and I have to acknowledge that in, you know, with my second monograph, because that was one of the main criticisms I had from my first monograph. You know, the clear distinction between passions and reason. And I'm going back once again here to Imer, and very clearly, people point out another lack here, the balancing. Are we talking about belief? Are we talking about desires? Or are we talking about both? I think here the author, excuse me, sorry, Verónica, but again, we are lacking of that precision. I'm going to go back finally, last but not least, the other way with William, the first and the third person. And again, I've seen a common thread. There's quite a lot to say in terms of goodness about this new encouraging development from Verónica, because she's there to put a theory together, to bring the legal, to bring the ethical into thought. She does quite a bit of the history behind, as we learned from Andrés. She actually deals with theories as well. However, there is a lack of, I would dare to say, discernment in the precision of the concepts that are backbone to her theory. If it had to be from me and my comment, I had to agree with all 4 commentators, and I think it stems from chapter 1. And that's why William Lucy, we started with you, and we started with the legal philosopher. We carry on with legal philosopher, and we finish with a philosopher, Herlinda. Because we see quite a few sciences or disciplines, law, one of the main ones, but then we have to bear in mind philosophy here. We have to ask ourselves this question, this presupposition. And I'm going to finish this. Is she going as a lawyer in writing this book and thinking as a lawyer, or is she thinking as a legal philosopher? I dare to argue she's thinking as a lawyer. She's having quite a few presuppositions that she's not making clear to the reader. So probably she should take a step aside and think as a philosopher in making clear these presuppositions or assumptions that the reader may not be that familiar with. And in that sense, we may avoid the difference between the first or the third person, passions and beliefs, the legal and the ethical. So I think it's only a minor comment that it stems through all the chapters we've been talking about. At least that's why, you know, my kind of approach after reading the book and after hearing all 4, it cannot be a coincidence. We all seem to agree there is a lack of precision in that sense. So thank you very much. I don't know if there is any other comment, but thank you, William, Imer, Andrés, and Herlinda. It's been a pleasure. Marichu, do you have anything else?
I do agree with all you have said, but we have a question also here in the chat from Emiliano Núñez.
Oh, my brother.
Yeah.
He's my brother. So
Yeah, well, it's to Professor William Lucy. Therefore, it's about, yeah, what he said about, is therefore the difference between the first and the third person irrelevant? And if it is that, so how this affect the book, this book, the structure of the book, and the argument of the book?
Okay, Emiliano, you haven't had the access to the book, I guess, then, is that right?
No, I showed the book.
Okay. Yeah. So for Veronica, this puzzle, well, the contrast between first person on the one hand and second or third person on the other presents a puzzle, and a part of the burden of the book is Veronica sets herself to resolve that, right? And she resolves it as we've seen with the number of the moves that Imer and Andrés commented on. She resolves it by reminding us of a better account of deliberation. She solves it by pointing to the significance of Croatia within that better account of deliberation. And the force of my point, such as it was, is just to, with the example I presented, to undermine or to blur the distinctness of the first and second and third person perspectives. Just with that example, because the third person, we're all there in the audience, and the first person is the striker on the pitch. And we, it seems to me, in that situation, we, the audience, and the first person, don't need to equivocate or move between too much, first and second or third person. Our reactions, our explanation are all the same, right? So the third person, those of us in the crowd who are watching the striker miss, say exactly the same thing about it as the striker themselves say. Oh my God, how can you miss that? Except she says, oh my God, how could I miss that? Our reactions are the same. We're all holding our heads and we're all thinking the same thing. First person, the striker, and us in the crowd. I mean, the only people who are happy about this are the opposition supporters, right? We're all saying the same thing. You normally take those chances. You normally never or do not often fail with those opportunities. You're better than that. You know you're better than that. And they themselves, the first person would say, I'm better than that. I normally score those opportunities. Honori's standard example when he speaks about can general and can in particular, it is about golf and sinking 6 meter putts. So and when we see a player coming to hit a 6 meter putt, and we see who the player is, we and they think this is easily achievable for this player. They normally do this, right? On this occasion, they fail. There's an instance of shortcut. So just with that example, it seems to me it blurs the big contrast that Veronica sets up between first person, forward-looking, third, second person, backward-looking. Because this event, when we think of shortcoming events or negligent events, and they take place in, let's put it this way, a relational context, right? I was trying not to say that since it's something that everybody wants to speak about. But when there's an audience, I don't think there's a big problem with first and third person. We're all kind of locked into the same perspective, it seems. And I think I've got an explanation why there's no big problem there, because it's not the first person, third person perspective is not a big problem for Honori and his account of outcome responsibility. So sorry, that's a really long-winded answer to your question. But for Veronica's book, the contrast is architecturally significant, right? It's the kind of starting. That's one of the problems she's going to solve. And I guess I'm asking whether there's a real problem there. That doesn't undermine what she says about the nature of deliberation and all the rest of it. And it is just a matter of starting. So I'm going to shut up there.
Very briefly, I want to add here, you mentioned William, sorry that about you mentioned William, Veronica solved the puzzle. But she not created the same puzzle. I mean, she's solving the puzzle she's creating herself. I'm learning that from you. I don't want to really that result I'm pointing out. She's solving the puzzle she herself created. So the shop is not good for thought. Un placer, Verónica. Any other questions?
She's not anymore here, by the way, but we are recording this, so it's just.
Thank you for pointing that out. Enjoy. Iain, we have a question here sorry, from the audience. Yeah.
Yeah, it's just going to ask the question because relevant to what William was saying. I was thinking about it ever since he said it. Like, my PhD was on legitimacy and ontological legitimacy. Sometimes I get the same questions, about thinking. It's sometimes used as justification for action post facto. And I find myself being in William's shoes. I have to tell a story about, well, the ontological legitimacy doesn't have to do when it's applied, so on and so forth. So I got to cut through this argument of the temporal issue. I have to explain that it's not an issue the way I construct legitimacy. But I didn't have the chance to read the whole book because I just got the invitation from Iain yesterday. I love to be here, by the way, it's the first time. But from my introduction, it seemed to me, and that's like, it's more like me inviting William to explain to me like a question. It seemed to me that the backward to forward, but because William was studying reading, the backward to forward point of view had a point of reference substance. So I'm just quoting, that's from the introduction, by the way. Sorry. In parallel fashion, there is a tendency to think about the negligent action from the backward-looking perspective only, i.e., once the suffering or harm on the part of the victim and the doing of the performer of the action have been unified. So this means that once a negligent action is done, the theorist looks at the injury or harm and establishes the grounding of the responsibility for negligence, ignoring the complex process of deliberation from the forward-looking perspective by the agent. The next sentence confuses. Anyway, but it seemed to me that what you're saying is this, the last speaker did mention of a level of abstraction that was
Caroline.
Nothing personal. So it seems to me that what goes on is here, somebody says an accident. Ex post facto judgment is negligence, harm. What we see is on a high level of abstraction, the direct causation between the negligence and the harm caused. How could you be so careless? You knocked up a kid, oh man, my bad, nobody, right? When you put yourself in the driver's shoes, there may have been other things going on that were relevant to the deliberation process. I mean, this negligence might have been not deliberation, but anyway, on that moment of action, which have led to the harm. Okay, the other person will understand these things as an external viewer. He didn't get my sleep and so on and so forth, right? But a significant part of the trial, if he goes to the court, assuming there's a gross harm, he's going to be trying to put the judge, if it's a criminal case, perhaps a jury, in that place of the driver. So in William's example, it would be, my God, how could you have missed it? But maybe there's other things going on that player, whatever, that is hard for the external point of view, the external third party, the ex post facto perspective to put their shoes on. So it seems to me that there is an issue of first level of abstraction, because then the ex post facto judgment is making an abstract connection between negligence, that accusation for harm. And the other one is getting in the context. I don't know, and you guys are much deeper into this. So is there something to it, or am I just misreading the claim for the introduction?
I mean, I can answer, but I don't think you're misreading. It should be Verónica here. I think we are all talking about the same issue, the lack of discernment of precision.
Speaking about the lady in front of me, Verónica.
No, Clara.
So can I just say
Yeah,
from the third person's perspective is, and one of the things I would have said in a long comment is undoubtedly the legal perspective on these matters, right? But I don't think we need that perspective in order to understand what's gone on. So phenomenologically speaking, when the striker misses a goal, or when we crash into somebody in our cars, neither we nor the audience there, as that event unfolds, need this backward-looking perspective. The law does, because of course things get contested, right? Because normally, nowadays we're all told, aren't we, by our insurers, if you have an accident, whatever you do not admit liability. And do not get out of your car and go, oh my God, I'm sorry, that was such an idiotic thing to do. That's what we should be doing, morally, if we've done something. And I've done it myself, right? But legally, that's not what we're supposed to do according to our insurers. So I think that legal backward-looking perspective, and it's the perspective that Monday night pundits on TV who analyse our every miss when it comes to golf or football. It's available, yeah. don't deny it, Bill. What I deny, though, is if it's particularly necessary to understand what's going on and whether it's what's gone on and whether it's necessary, whether it helps us with our evaluation system. The backward-looking perspective would be really helpful if I knew, and if we knew, the striker was had just lapsed into a state of automatism. They got low blood sugar, just like the driver, right? That would make a difference to our evaluation. But if the striker, if reason is at home in some way, if intentionality is in the building for them, for what they're doing, just like the driver, I don't think we need to label too much with the back. The courts do, and the pundits do. But it's quite intelligent, the rest of it. So that's Matt. But if Veronica was here, of course, she will
run away. I'm coming from Imer. That's right, Imer.
Yes, we have here Imer, and yeah, I think that with Imer we're closing the comments here online. Unless Aline would like to react as well.
Yeah, actually, I think I am. Yeah, that was my reading. And again, probably it is Veronica, the one who has to tell us you're all getting it wrong. You're all misleading. There was one of the other examples that she used besides the case of Alexandra. She used the case of Beatriz, and of course she goes back and forth. And I think that's the important part, even though I think we agreeing that is the first person. And I understand why Veronica wants to call it aspirational, upward, forward-looking, but my feeling is that it's always going back and forth. In the case of Beatriz, she wants to get her daughter into gym class, and then her daughter turns to be too aggressive, too competitive, and that seems to be not very good. So somehow we, as parents, imagine we will have to engage in that and try to help our kids to be better grasping of the importance of being competitive, but not violent against others or aggressive in a bad way. Probably aggressive in the other sense would be good. But so then she thinks, oh, but she's also good in ballet. She's also good in tap lessons, and probably the gymnastics as well. So she will probably keep pushing a little bit on how far, and again, it's still one person, the first person who's making but at some point she brings another set of ideas on the possibility of Beatriz seeing a nice coat in a very expensive one and decide, oh, I'm going to buy this coat, even though that means that she's not going to get her daughter to the gym class anymore because she couldn't afford to do both things. Of course, she will. But that's what I'm trying to suggest, that we are always going back and forth. So I think that's the beauty of the argument of saying no to the bifurcation thesis, no to the way the balancing model seems to work, finding an aspiration, deliberation, integration between all the different aspects that are at play. And insist it's not only forward, it's going back and forth, but it's probably still in the first person, who is probably reacting to what other people will say. And again, in the case of the dog, it's clearly that she missed the idea of not being Alexandra, not being aware that it is we are in a heat wave. That if the car is closed, they will probably get into a heat stroke for the dog. Probably she will have to lower the windows. But again, it's not only forward; it's backward. And I agree in the idea of negligent acts. What we are responsible for not foreseeing that we had to open the windows or take less time or be conscious of time, that we have only, let's say, 5 minutes instead of just having to spend a lot of time and so on. So I think, again, that's my take, that she needs to do both the forward and the backward. I understand that she wants to move to the upward because she really wants to go into this idea of the aspiration of in the very Greek sense of making our lives well, living well in a very adverbial way. So I think that's I think it's a very nice project, but I think we all agree that there are little tuning knobs and little precisions to be made. And well, congratulations to Verónica again.
Many thanks, Imer, for your comments as well, your reactions. And I think that we have Erlinda. Yeah, thank you so much to you as well. With you, we're closing the comments in the, at least from Zoom.
Yeah, thanks. I would just like to add something. I have to, okay. I think, William exposed the problem of the different perspectives perfectly, right? And as I understood his argument is there is no disagreement if we look at the whole situation, right? Including all the agents, there is not, all three standpoints are in play. The third person standpoint, the second person standpoint, and the first person, and they agree on the same judgment. And I would like to add something here, right? That's exactly what's important, right? All three perspectives have to be in play, right? And if we associate it with the kind of institutions and persons we have here, so we have the first person, who of course we expect in a legal procedure, in legal proceedings, or when negligence is at stake, also to look into themselves, right? And have something like remorse, understand the blame, understand the what has happened, right? On the other hand, we have in the accounts I presented, the Ripstein wine rib, we have the second person standpoint. It's, as they say, a bipolar relation between rights and duties, right? And between two persons where one person has violated the rights of the other, has done damage and so on. So we need the second person, or we have the second person standpoint as Darwin would call it. We have it in place here as well. And then the third person perspective. As much as I can, I find it attractive, Veronica's argument that the judge should ask him, her, or themselves what's going on in the deliberation of the defendant. The first person perspective has to take also into account the plaintiff, right? But the judge also has to present the legal institutions, and that's what we expect the judge there to have a third person perspective on things, right? We don't want, and the judge need not get into the first person standpoint in the full-blown sense, right? Because the judge is not the one who has to blame him or herself for the negligent act because the judge didn't commit it, right? But the judge has to come to a fair verdict on the case. So I think William's point is very valuable, right? In connection to the whole picture here.
Well, Marichu, do you want to, we'll do Marichu, you and me, and then we close. Thank you very much. Marichu, you?
Yes, thank you so much. I am so looking forward to listen to Veronica's answering these questions, comments, and reactions. But I think that we are all a little bit out of time. Thank you to all of the people who joined online. Thanks to our brilliant commentators again, Imer, Erlinda, Dr. William Lucy, and for sure, Iain Brassington, who made it possible, who opened the door for us to be here in a great inauguration of the Juris Nord seminar, and to our big star, amigo, querido, my friend, my colleague, Jorge Núñez. Thank you so much.
Un beso. Yeah? Now you want to...
Apparently, thank you. Thank you all for coming. Apologies for the slight IT problem to start, but yes, that is what it is. I would just like to echo what Mary-Jo said and thank all the speakers for coming along. I haven't yet had a chance to read the book because it's marking season and I've not had a chance to do anything. But I will, and yeah, it sounds fascinating, and I'm looking forward to taking the mental notes that I've been making this afternoon and applying them in the margins as I read it. So thanks to everyone for coming, thanks for participating. And yeah, Jorge, I'll let you close the floor.
Right, yeah, I'm here.
Yeah, the camera's there.
One thing I wanted to say, we started this dream with Verónica, and some people that are new to the team, we are not destroying our book. That's how we work at Original. We collaborate, we don't compete. So years ago, we had the pleasure to present William's book at Liverpool. Mike Gordon was there chairing the session. I'm simply their face, I'm the one that takes the executive decision. But it's been a pleasure because at the time we were on our own, two foreigners, Verónica from Venezuela and myself from Argentina, finding ourselves quite isolated doing jurisprudence in this country. It's been a pleasure to work with, and even you may feel to hear some comments a bit harsh. That's how we work, because we want to improve ourselves, and we do collaboration. In particular, I want to say thanks to Verónica, because thanks to our chat 9 years ago, we started this. We didn't want to have more, and I'm going to quote her, Verónica, sorry about this, but we didn't want to have more mental masturbation. We wanted to produce, to work together, and that's what we've been doing. Thanks to William, and not only for the comment, but for being with us all these years, Mike Gordon, and Peter Stern, and all the others, and in particular, Iain, not only for hosting us today, no, you did. Because you believed in us 8 years ago with our first presentation. Remember, we were like 6 people at the time at Manchester Metropolitan. And we've been running the show for 8 years, online, hybrid, virtual, and so on. So once again, and in particular now, because one of the things we did last year, we studied for the first time in Spanglish and Portuguese. And then we get replicated. I'm going to say this because we get replicated like other discussion groups. We have discussion from transgender people. We have discussion from males and females. We have even discussions with deaf people using sign languages. I'm very proud to say we are a really inclusive network. We have students, we have PhD students, and we have professors like from the Yale, from Harvard, from Cambridge. I'm not going to name one because I'm going to forget them all. We've had more than 100 speakers from Africa to Asia to Latin America. I want to say that because we tend to get copied quite a bit internationally. And we do that with our own resources. Thanks to all our universities, because we all have food now for 50 people here. As I have to say, thanks to University of Manchester, Manchester Metropolitan, Durham Law School, and so because they actually were happy, to host our events, and they are still happy. And finally, gracias Verónica, gracias Marichuy, thanks Iain, gracias Imer, gracias Andrés, thanks Arlene, and thanks my favorite legal philosopher, William Nixie. Thank you all. Thank you.